will go on the record, KC 333684. Just want to make sure there's anything we need to address before we bring the jury in.
No, you're not. Like I said this morning.
All right, thank you. So,
my bad.
Well, I think that you had us leave the offer open.
I did, I understand it's being rejected, but let's just double check. Good afternoon, Mr. McDonald, how are you?
Good afternoon, Judge.
All right, let the record reflect the presence of Mr. McDonald and his attorney. I understand you're going to reject the offer that was made this morning, is that correct?
It's for a felony charge, yeah, I'm not sure, Judge.
Okay, all right. So everyone, be at ease. We're just waiting for the jury to line up, and then we will get started.
Okay, thank you.
Thank you.
Oh, it was nice. We were actually going to set up here. Was it?
I need to go to the ocean after those. See the ocean.
Yeah. I kind of agree with you.
Howdy. Great. Who's back on the record? All right. Here we go. Back on the record in case C18333684, State of Nevada versus Michael McDonald. There's one juror I'm going to bring in first before we bring in the rest of the panel, and it's juror number 413. Apparently the juror services advise that he is a convicted felon, or she is, I'm not sure. But I wanted to talk to that person before we bring in the rest of the panel. So Greg, you go ahead and give it a chance, and then we'll get started with them. Good morning, yeah, let's call case C18333684, State of Nevada versus Michael V. McDonald. Good morning, Mr. McDonald. Right, now the record reflects the presence of the Deputy District Attorneys as well as Mr. Mueller and his client, who is dressed out for trial. Anything we need to address before we bring the jury in?
Yes, Your Honor, the state actually has three things that need to be addressed.
Okay.
I think the first one will be fairly brief. The second witness that we'll be calling today, Detective Colby Karchner, the state is requesting no-face filming for him due to the nature of his work. I've already spoken with the camera operator from the media. She assured me that she will not be filming his face, and I believe the procedure is for jabs that we would need the camera disabled that films the witness's face during his testimony.
Okay, and what is the nature of his work?
Potential undercover work in the future.
He does potential undercover work? Okay. All right, well, that will also be granted. I understand you're going to comply with that, so please, that will be the order of the court. And then, can we turn off the camera for him? How do we do that?
Let me, when is he coming on?
After lunch.
After
Yeah,
lunch?
he will be the second witness, and
Okay,
our
perfect.
first witness will be
So we'll get
much
that.
longer.
Okay, let me figure that out.
Resolved after. Okay. Okay, thank you.
And also for the record, the camera operator assured me that there's no live streaming going on at the trial. They're just recording to.
Okay, I appreciate that. Thank you.
The second issue, it came to my attention this morning that Steve Sampson, the head of Veterans in Politics International, who was here in the courtroom yesterday, I haven't seen him today, he made a Facebook post. Today in which he made a statement regarding who was on the jury panel. Specifically, he stated, Judge Cristina Silva had jury selection for the Michael McDonald matter. Surprising there was a family court litigant sitting as a potential jury. I think he meant potential juror, not potential jury. Unfortunately, he's not here today. It's just, basically there are two things. I mean, one, I think if he were here, I think he would need to be admonished by Your Honor not to be posting things about the jurors. Two, I'm hoping that he was referring to the person that was in the potential jury panel who stated that she knew the defendant and Mark DiCiero. That may be who he's referring to, in which case it's fine.
Right.
But if he's referring to somebody who actually got seated as a juror, that's concerning to the state, because yesterday during voir dire, my co-counsel asked all of the people on the panel if they were familiar with Steve Sampson. They all indicated they didn't. So if we have someone who's being dishonest about that, But I don't know how to deal with that if Steve Sanson's not here, but I need to.
And until that's brought to our attention, or if it's even brought to the attention, the jurors will have to bring that up. We're not, of course, gonna have to operate, but I'll certainly note that, and if there's another issue, I'll address it when we need to.
Okay.
Okay?
Okay, and third and final issue, yesterday Defense Counsel stated an intention to call a witness by the name of Scott Bradley. The defense has never noticed any witnesses in this case, so the state requests that the defense be barred from calling this person Scott Bradley pursuant to NRS 174.234. All witnesses must be noticed in writing along with the address of that witness at least 5 judicial days prior to trial. There was no notice at all of this witness, and to make matters worse, defense counsel may point out that there was verbal notice of the witness at the initial calendar call on December 18th, but defense counsel's associate actually stated that it was someone named Scott Bailey who would be appearing. So there's been no written notice at all, and arguably they've indicated that it was someone with a different name. The state knows nothing about this witness, and I think it would be unfair for them to call this witness. Additionally, based on questions that were asked during voir dire and statements made by defense counsel at the last mistrial, it appears that defense counsel intends to argue that the defendant was outside of the jurisdiction at the time these phone calls were made, and the state's position is that's essentially an alibi defense. Black's Law Dictionary defines an alibi as a defense based on the physical impossibility of the defendant's guilt by placing the defendant in a location other than the scene of the crime at the relevant date and time. That's essentially what that defense is. And as we all know, pursuant to NRS 174.233, such a defense must be noticed at least 10 days prior to trial in writing, along with noting the witnesses, the nature of the alibi defense and the witnesses who will be presented regarding that defense.
All right, so let's take the witness first. Mr. Mueller, is it still your intention to call that witness?
We've been investigating to try to get a hold of Mr. Bradley. We have not been able to do so.
So that issue seems probably will likely resolve itself. So I'm going to defer on that ruling until that is an issue. However, if you do intend to call him, you will have to let the court know ahead of time so we can address the lack of notice issue outside the presence of the jury. Turning to the alibi defense, Mr. Mueller, do you intend on calling a witness that is going to put your client in California at the date and time, or outside the state of Nevada?
I respectfully decline to play my defense for my colleagues before it's presented. Number two, my colleague in her industry seems to confuse two very basic concepts. Alibi defense was I wasn't there. Jurisdiction is absolutely a central element of every crime charged. There might be the most heinous murder in the world in New York, and my colleague can be upset if she wants about it, but the reality is there's no jurisdiction in Nevada for it. Now, if this phone call was made in California, there's no jurisdiction. You still have to plead and prove jurisdiction just like any other proceeding. So I believe now, this is a divorce. I don't know if the court's had the pleasure of actually going to family court. There's been absolutely no cooperation with any witnesses prior to trial. What the testimony brings today is going to be what it brings. So we will have to respond to testimonies as adduced.
All right, Ms. Mishler, how do you respond to the fact that he's arguing this is an alibi as much as a jurisdictional argument?
I understand that jurisdiction is related to this, but essentially if the defense is, well, he was in another physical location at the time of the offense, that is the essence of an alibi defense as well, even if it is relevant to jurisdiction. He's saying it was physically impossible for him to commit the crime because he was in another physical location at that relevant time, and that's in essence an alibi defense, and there's no reason that written notice could not be given of it.
That's not an alibi defense. That's a fundamentally different concept. My colleague is trying to protect her case prospectively and asking the court for an advisory opinion, and I object to both.
All right, I'm going to deny the request to preclude argument that the defendant was in California. Certainly the defendant is going to have to put forward more than argument to support any claim that he was in California at the time. This is shoehorned to another concern the court has based on questions that were raised during voir dire yesterday. there were questions about an understanding of whether there's different laws that take place in different states and federal versus state law. Mr. Mueller, I understand you have a right to question the jury, but you don't have a right to confuse the jury regarding what is going to be the applicable law in this case. And to be clear, the applicable law and the laws that he is charged with violating are state of Nevada laws. And so there is going to be a question as to relevancy regarding other laws of other jurisdictions. And so I'm cautioning you now outside the presence of the jury to tread lightly as to not confuse the jury regarding what is appropriate and what they should be considering.
I understand, Judge. I've got supported case law, and when I get to the jury instructions, we'll see exactly what I'm going.
Well, I will want to see that case law before we get to the point of jury instructions. If we're going to be arguing that in front of the jury or asking questions about it, I think it is important that I review and make a decision on that issue well before we get to the issue of jury instructions.
Thank you, Judge.
All right, so anything else that needs to be addressed?
Not from the state, Your Honor.
Okay, all right. Thank you, and if anything else is brought to your attention, please let me know. Let's go ahead and bring the jury in.
You're going to convince me to hold your client in contempt.
Raise your right hands, face the court clerk to be sworn.
Seasoned judges get contempt Raman all the time.
I find you in contempt. I am going to incarcerate you.
Any statement that you make is under penalty of perjury.
Nope, that's not how that works.
We will take this case under submission.
That would require proof by very significant evidence.
All rise for the jury.
Jury is all present, Your Honor.
Good morning, please be seated. Do the parties stipulate to the presence of the jury?
Yes, Your Honor.
Yes, Your Honor.
All right, welcome back, ladies and gentlemen. I see many of you have jackets or scarves, smart, hiding ahead. Today will be cold, tomorrow will be hot. You never can tell with the temperature control in here, so I'm glad you're prepared. We're going to start this morning. I'm going to read you some pretrial instructions, and then we're going to proceed into opening statements. And just to give you a little bit of a preview on timeline, I anticipate we'll go for about an hour and a half, and then we'll take a lunch break, and then we'll come back and we'll review with the rest of the trial this afternoon. So let me go ahead and get started with these pretrial instructions. Ladies and gentlemen, you're admonished that no juror may declare to a fellow juror any fact relating to this case of his or her own knowledge. And if any juror discovers during the trial or after the jury has retired that he or she or any other juror has personal knowledge of any fact or controversy in this case, they should disclose that situation to me in the absence of other jurors. Let me decode that for you to non-lawyer talk. That's an instruction I'm required to give, but what that basically means is you are required to let me know if during the course of the trial or even during deliberations that you realize that you know something about this case that you didn't know previously. As an example, sometimes an individual you know as William is announced as being William Smith comes in, and turns out that William has a nickname named Buzz. You only know William as Buzz, and so that person walks in the door, the person's a potential witness, you're like, oh, I know that person, that's Buzz. You are to write that information down on a note, don't share it with your fellow jurors, give it to the marshal, and we'll address it outside the presence of the other jurors. That way, that information isn't being shared amongst yourselves. It's just a way to make sure that we're keeping the process clean and the facts and the evidence that are presented before you the same and equal amongst everybody, so nobody has an advantage about any particular fact or any other fact. Does that make sense to everybody? I see everyone nodding their head. Okay, all right. So that's a non-lawyer translation of that. As I advised yesterday, the way that you communicate with the court is through our marshal, Marshal Staney. He will be present at all times we're in session. And again, you should write down any concerns and pass it to him for my review and possibly review with the attorneys. Again, I remind you, during the course of the trial, the attorneys for both sides and court personnel, myself included, aren't permitted to engage with you. I can talk to you here and give instructions, but if I see you at a lunch break and I don't say hello, or the parties don't say hello, please don't take offense to that. We are merely following the oaths and rules we are bound to. All right, I'm also going to admonish you that you're not allowed to visit the scene of any acts or occurrences that might be mentioned during the course of this trial, unless I specifically direct you to do so. Though really a place isn't so much an issue here, it could be, in various places could be mentioned during the course of testimony. And the reason for that is places can look different or seem different than they were, let's say, 2 years ago. As we know, as people that live in Clark County, as an example, an intersection can have a stop sign 1 month, and 3 months later there's a stoplight there. So things change, and that's why we ask you not to go visit any places without instruction of the court. If there is a need to take a look at a place, oftentimes there are photographs that you can take a look at if necessary. The parties may present some objections to testimony or other evidence. At times I may sustain those objections and direct you to disregard certain testimony or exhibits. You must not consider any evidence to which an objection has been sustained or which I have instructed you to disregard. Other times I might overrule the objection, meaning you can consider whatever testimony or exhibit has been introduced. It is the duty of a lawyer to object to evidence which he or she believes may not be properly offered. And you should not be prejudiced in any way against a lawyer who makes objections on behalf of the party he or she represents. And may also find it necessary to admonish the lawyers, and if I do, you should not show prejudice towards the lawyer or his clients or her clients because I find it necessary to admonish them. Throughout the trial, if you cannot hear a question asked by an attorney or the answer given by a witness, please raise your hand as an indication. If I or the marshal see your hand up, we'll know that there's an issue and we'll address that as soon as possible. If for whatever reason we miss your hand, feel free to stand or just say, excuse me. We want to make sure that you're hearing the questions and the answers to those questions. If you wish, you may keep notes to help you remember what the witness has said. You will have those notebooks in your hand. I ask that you don't let note-taking distract you so much that you get the answer to one question but miss the answer to the following 2 or 3 questions that go behind that. You should rely upon your memory as to what was said and not be overly influenced by the notes of your notes or the notes of other jurors when you go back to deliberate. The case will proceed in the following order. First, the plaintiff here in the state of Nevada has the opportunity to make an opening statement outlining its case and suggesting what it will believe the evidence to be, or will be during the course of the trial. The defendant may then make an opening statement, or may reserve his right to an opening statement until after the state has put forward all of its evidence. Opening statements are a synopsis or an overview of what an attorney believes the testimony and evidence will be. Opening statements of the attorneys are not evidence. After all, the attorneys are not witnesses to any facts and controversy in this case. The state will then introduce evidence and call witnesses. At the conclusion of the plaintiff's case, the defense may call additional witnesses and submit additional evidence if it wishes to, but there is no obligation. After the defense rests, if they put on a case, the state has a right to put on a rebuttal case and potentially call rebuttal witnesses. After all the evidence is in, I will instruct you on the law that applies to this case. You must not be concerned with the wisdom of any rule of law stated in these pretrial instructions or in the instructions given to you at the end of trial. Regardless of any opinion you may have as to what the law ought to be, it would be a violation of your oath to base a verdict upon base a verdict upon any other view of the law than that given to you by the court. And with that, we actually need to administer their oath. So let's go ahead and do that now, and I'll finish the instructions. If you can all please rise.
Raise your right hands. You and DiCiero do solemnly swear that you will well and truly try this case at issue and a true verdict render according to the verdict, so help you God.
All right, please be seated. After the instructions at the end of the case are read to you, each party will have the opportunity to orally argue in support of their case. This is called closing argument or summation. What attorneys say in closing arguments is not evidence. Their arguments are designed to summarize and interpret the evidence for you and show you how the evidence and the law relate to one another. Since the state has a burden of proof, they get to argue twice. They get to provide a summation, then the defense provides a summation, and then the state can put on a rebuttal argument. After the attorneys have presented their arguments, you will retire to select a foreperson to deliberate and arrive at your verdict. Faithful performance by you of your duties is vital to the administration of justice. It is your duty to determine the facts and determine them from the evidence and the reasonable inferences that arise from such evidence. And in doing so, you must not engage in guesswork or speculation. The evidence which you are to consider consists of testimony of witnesses and exhibits admitted into evidence. The term witness means any person who has testified here in court. The admission of evidence in court is governed by rules of law. From time to time, it will be the duty, as I mentioned earlier, of the attorneys to make objections, and my duty as the judge to rule on those objections and decide whether a certain question may be asked or answered, or whether certain evidence may be admitted. You must not consider anything to which you have seen or heard when the court is not in session, even if what you hear or see or what was said or done by any of the parties or witnesses to this case. While you're in the courthouse, again, I remind you that you are to wear that badge, and that way you are identified as a juror. And that means even when you're walking from the parking garage into the courthouse, I'm sure, well, hopefully when you all arrived, it wasn't quite so bad, but I'm sure perhaps yesterday morning when you arrived, you witnessed the long line that can sometimes form to the end of the courthouse. People don't know what you're here for, and we want to make sure that people are mindful of the fact that you're jurors. Again, I suggest that you chit-chat amongst yourselves, or even better, perhaps other individuals with juror badges that are considering another case. You can talk about anything but the cases that you're sitting as jurors on. In every case, there are 2 types of evidence, direct and circumstantial evidence. Direct evidence is testimony by a witness about what that person saw or heard or did. Circumstantial evidence is testimony or exhibits which are proof of a particular fact, from which, if that fact is proven, you can infer the existence of a second fact. Let me interpret that again from law talk. let's say we've been in this courtroom for several hours, and an individual comes in, and they're wet, their clothes are wet, their hair is wet. You might think to yourself, I wonder if it's raining outside. If that person walked in the room, had the same look, but was also carrying an umbrella, and that umbrella was wet, that is circumstantial evidence that it was in fact raining outside and they had come from the outside in and were wet. That's circumstantial evidence, and you can infer that it was raining. It's just an example of what that looks like. You are allowed to consider both direct and circumstantial evidence in deciding this case. The law permits you to give equal weight to both types of evidence, but it's up to you to decide how much weight to give any particular piece of evidence. Opening statements and closing arguments are intended to help you understand the evidence and applying the law. Again, I remind you the attorneys are not witnesses, and therefore, excuse me, anything they say is not evidence. Excuse me. I may also take notes during this trial as to what the witnesses are saying. Do not make any inference from this action on my part. I am required to prepare for legal arguments the attorneys will make during the course of the trial. And for that reason, I might take extensive notes on some issues or not others. And I also sometimes take notes electronically. I try to be quiet when I'm doing that, but I am required to take notes, and I do that. I'm also going to remind you again not to talk to anybody at home. I know you all went home last night and you haven't heard any evidence, but today we're going to start the presentation of evidence. And I ask that you don't talk to your family or friends or employers or anyone else about what you've heard here today. That's something that you can do at the conclusion of the case. And sometimes it's hard. People want to know, like, hey, what's happening? What did you hear? Just let them know the judge instructed you. I can't talk about this until the case is over. If you need a note for your employer, please let Marshall Stamey know, and we'll take care of that for you. And we can provide that on a daily basis or on a weekly basis, whatever you need. That's not a problem. We'll get that taken care of for you. And we can certainly give them a note also to let them know when we anticipate the trial being over. So it's up to you. Just let us know. All right. Do not make up your mind about what the verdict should be until after you've gone into the jury room to decide the case and you and your fellow jurors have discussed the evidence. It's important throughout the trial to keep an open mind and hear all the evidence before deliberating. At the end of the trial, you'll have to make up your mind regarding what you recall of the evidence, and you'll have to discuss this case and the evidence with your fellow jurors. You will not have a written transcript to consult. Even though we have Ms. Villani here recording everything, it is recorded, it's not transposed into a transcript immediately. And so you are going to have to remember what the testimony was. I urge you to pay close attention to the evidence presented and the testimony given by the witnesses. I'm going to ask the state to read the indictment at this time, the information, the charging document.
Okay, even though we did that yesterday?
Did we read the whole thing or we just read them? Or did have Ms. Donahue do it? I'll go ahead and have Ms. Donahue do it.
Oh.
Okay, all right, that's fair enough, if you don't mind. This is the charging document. The charging document is merely informs Mr. McDonald of the charges he is facing. It is not evidence.
District Court, Clark County, Nevada, the state of Nevada plaintiff versus Michael E. McDonald, defendant, case number C-333684, Department 9, amended information. State of Nevada, County of Clark, Stephen B. Wilson, District Attorney within and for the County of Clark, State of Nevada, in the name and by the authority of the State of Nevada, informs the court that Michael E. McDonald, the defendant above named, having committing the crimes of unlawful interception of wire communications on or between August 1st, 2016 and November 30th, 2016, within the County of Clark, State of Nevada, contrary to the form, force, and effects of statutes in such cases made and provided and against the peace and dignity of the State of Nevada. Count 1, unlawful interception of wired communications. Did willfully, unlawfully, knowingly, and feloniously intercept or attempt to intercept a wired communication without the knowledge or consent of Candace McDonald or Candace Ruiz by recording a phone conversation between the defendant and the said Candace McDonald and or Candace Ruiz without her consent, wherein they discussed daycare costs. Count 2, unlawful interception of wire communications. Did willfully, unlawfully, knowingly, and feloniously intercept or attempt to intercept a wire communication without the knowledge or consent of Candace McDonald and or Candace Ruiz by recording a phone conversation between the defendant and the said Candace McDonald and or Candace Ruiz without her consent, wherein they discussed doctors, child protective services, and or allegations against her boyfriend. Count 3, unlawful interception of wire communications. Did willfully, unlawfully, knowingly, and feloniously intercept or attempt to intercept a wire communication without the knowledge or consent of Candace McDonald and or Candace Ruiz by recording a phone conversation between the defendant and the said Candace McDonald and or Candace Ruiz without her consent, wherein they discussed her new boyfriend and or the dietary needs of the children. Count 4, unlawful interception of wire communications. Did willfully, unlawfully, knowingly, and feloniously intercept or attempt to intercept a wire communication without the knowledge or consent of Candace McDonald and or Candace Ruiz by recording a phone conversation between the defendant and the said Candace McDonald and or Candace Ruiz without her consent, wherein they discuss family court proceedings. Count 5, unlawful interception of wire communications. Did willfully, unlawfully, knowingly, and feloniously intercept or attempt to intercept a wire communication without the knowledge or consent of Candace McDonald and or Candace Ruiz by recording a phone conversation between the defendant and the said Candace McDonald or Candace Ruiz without her consent, wherein they discuss court issues and or dietary needs of the children, signed by the district attorney, to which the defendant has pled not guilty.
Thank you, Ms. Donahue. All right, we are ready to begin opening statements. When you're ready, Ms. Mishler.
Thank you, Your Honor. Ladies and gentlemen, this case, the state of Nevada versus Michael McDonald, is about privacy, a criminal violation of privacy. The evidence will show that the defendant, Michael McDonald, recorded 5 telephone conversations that occurred between himself and his ex-wife Candace. And the evidence will show these phone calls occurred between August 1st of 2016 and November 30th of 2016. And you'll hear testimony from Candace. She's Candace Ruiz these days because she's remarried. At the time of these phone calls, she was Candace McDonald. And she will actually testify that she's certain these phone calls all occurred in October of 2016. But to cover our bases, we charged this particular time range just to be sure we were accurate. And you'll listen to these phone calls. And on these phone calls, the defendant and Candace, they discuss very personal things: their past relationship, child custody issues, daycare costs, and health issues regarding their daughter. And I apologize to you if you're the kind of person who gets grossed out easily. You'll hear more about their daughter's bowel movements than you ever wanted to know. And if you don't know what a rectal prolapse is now, you'll learn what that is by the end of the trial, which you probably don't want to learn. But unfortunately, that's the nature of what they'll be talking about on these phone calls. They're very private, personal things, not things that Candace expected to become this public of nature. And to give you some background, the defendant and Candace, they met at a country western music bar in 2008, and they got married in 2010. And they had children right away. They have 2 children together, Mason and Malia. Mason was born in 2011, and their daughter Malia was born in 2014, and she's the one that you'll hear the most about. Candace files for divorce in 2015, and the divorce is finalized in October of 2016. That's when the decree of divorce is signed and the divorce becomes official. But of course, as you probably know, since they have children together, their family court case isn't over just because they've gotten divorced. They have child-related issues that they have to deal with: child custody, child support, things like that. So there are repeated family court hearings involving the defendant and Candace. And so now we're into late 2016, 2017. The defendant is not happy with how his family court case is going. He doesn't like the judge. He thinks the judge is biased against him. He's not happy with the child support. He's not happy with the child custody arrangement. He just feels he's being treated unfairly. And he gets a video of a number of the hearings that occur in family court in his case, and he posts them online. some on YouTube, other websites. And he starts talking online and posting comments, complaining about how he's being treated in his family court case and asking others for opinions and advice about his case. And this is how he comes to the attention of Mark DiCiero. And Mark, some of you recognize him because of his former career in radio from Mark and Mercedes in the Morning, but he stopped doing that in about 2015, and he became more interested in the law here in Nevada, particularly family law, because he had his own family court case at one point. And around this time, he begins working as a paralegal, and he also becomes the co-administrator of a Facebook group called Nevada Court Watchers. And this isn't some official organization or anything like that. It's just a Facebook site that's been created, and it's essentially just a web forum where anybody can go and they just talk about different things related to court cases here in Nevada, mostly here in Las Vegas. And they talk about any court cases, but there's an emphasis on family law, like mainly because a lot of these people are pro-per family court, so they ask for advice. Occasionally family lawyers in town will, as a public service, will just answer some questions, things like that. So that's what's going on in this group. And Mark, as part of being co-administrator, he looks around online for things going on the news, things going on related to court cases here in Nevada. So he looks at videos and things on YouTube and other sites, and he sees what the defendant's doing. He sees these hearings, and he wants to know more. He wants to see if this is something he should post links to on Nevada Court Watchers. So he sends the defendant a Facebook message and says, hey, I heard about your case. Do you have any other videos of hearings that I can see? I'd like to take a look at it and see if people on Nevada Court Watchers would be interested. And the defendant gives Mark a link to his Google Drive, or specifically to a couple of folders in his Google Drive. And they contain not just video files, but there's audio files, there's a lot of documents related to his court case. It's quite voluminous, so Mark doesn't sift through everything when he first gets this link. He looks at some things, but he doesn't look at absolutely everything. And a few months go by, and Mark actually sees some YouTube videos that the defendant posts, which sound to him like audio recordings of telephone conversations. And then Mark takes a look at the Google Drive link, which is still active, and he checks out some audio files. And when he listens to them, he hears what sounds like recordings of 5 different phone conversations between the defendant and Candace. And he recognizes their voices because he's seen these family court hearings that the defendant has posted. So Mark sends Candace, the defendant's ex-wife, a message through Facebook, and then eventually he emails her the phone calls so she can listen to them, just so she can confirm what they are. And Candace, of course, she listens to them, and she recognizes them as conversations that she had with the defendant, Michael McDonald. And she recognizes them based on the content of the conversations. There are a lot of clues within the conversations indicating when these phone calls happened. They sort of indicate the progress of their daughter's gluten intolerance and how it led to a rectal prolapse and the status of their divorce and their custody situation. And most importantly, Candace had no idea that these conversations were being recorded. She had no idea. And she never, ever gave the defendant permission to record these telephone conversations. The defendant recorded these telephone conversations, these 5 separate telephone conversations, without Candace's consent. And that is why the defendant is charged with 5 counts of unlawful interception of wire communications. And I'm confident that at the conclusion of this case, you will find the defendant, Michael McDonald, guilty of all 5 counts. Thank you.
Thank you, Ms. Mishler. Mr. Mueller, if you'd like to present your opening statement, you may proceed.
Thank you. Ladies and gentlemen, jury, if you were paying close attention, you saw that the state's case is as fishnet. We talked about feelings. We talked about divorces. We talked about communications. What you heard was 0 facts. A busybody, somebody who went out of his way to get involved in people's business he's got no relationship to, hacks a Google Drive account. He, that busybody, thinks that these are recordings. He then suggests to a venomous ex-wife that they are recordings, and therefore a crime has been committed. What you are not going to hear, and you're not going to hear, is anybody said, I recorded this. You're not going to hear the original recordings because all the documents the state's going to give you, the evidence will show, are edited so that they don't begin with opening statements like, hello, how are you? They don't end with, I don't want to talk to you ever again. No, you're going to hear just snippets of conversations, and they are auto-edited by people with malice. And what you're not going to hear at the close of statements is who actually recorded the statements. You're not going to hear when they were actually recorded. You're not going to hear any proof that they were, in fact, actually phone conversations. You're not going to hear the original documents, and you're going to hear from this busybody who's an expert in audio editing for his former job as a radio DJ. This case is not guilty. It requires evidence to convict somebody of a case, and the state will offer you nothing other than feelings and venomous bile from an ex-wife. At the end of the evidence, we're going to ask you to find Mr. McDonald not guilty of all accounts.
Thank you, Mr. Mueller. All right, the state, you may call your first witness.
State calls Mark DiCiero.
Thank you. Then you're allowed to ask questions, and so after the parties have questioned the witness, if you have any questions or you think of questions that you might want answered, write that down in your notebook. We can tear that off. Ultimately, I will confer with the parties before I ask any questions to determine whether or not they can be asked. There are some questions that can never be asked for reasons not allowed under the law, but I will make that determination. If your question is asked, you should not give it any extra weight. And if your question isn't asked, you aren't to speculate as to why it wasn't asked. It's just part of my decision as the judge to make certain rulings about what can and cannot be asked. Don't let me forget, if you have a question at the end, please raise that so the witness doesn't leave before that question is asked. Good morning.
Yes. You do solemnly swear the testimony about to give in this action shall be the truth, the whole truth, nothing but the truth, so help you God.
I do.
Please be seated.
Thank you.
And then state and spell your name for the record.
First name Mark, M-A-R-K. Last name DiCiero, D-I-C-I-E-R-O.
Thank you. Mr. Raman, when you're ready.
Thank you. Mr. DiCiero, can I call you Mark?
You may.
Mark, what do you do for a living?
Currently, I am a law clerk and paralegal for a family law attorney in town. I also run my own paralegal business to help people in family court, draft pleadings, help with procedural issues. And I am also a radio personality, which I do part-time now. Used to do that full-time. So a few different things going on right now.
And which attorney do you work for?
Alex Gabato.
Does he practice family law?
He does.
You are a law clerk for him?
Correct.
Okay. And then you have your own business, which is a paralegal business?
That is right, yeah.
Is that separate and aside from your work with Mr. Gabato?
Completely separate, yes.
And you still do some part-time on-air radio personality work?
Correct.
For what radio station?
Most recently, Sunny 106.5, iHeartRadio. That wrapped up recently. May start back up again here in 2020. We'll see how the schedule permits. It's just something I do now because I just really enjoy it. Something I love.
Okay. Have you previously had a more full-time role as a radio personality?
Yes.
In what context?
Let's see, from 1997 through about 2015, I was the host of the Mark and Mercedes show for CBS Radio here in Las Vegas, and came from Colorado for that job. And like a lot of people, thought I'd be in Las Vegas for a couple years and move on, but 20 years went by in a heartbeat. So did that up until 2015.
Okay. And it seems like a big transition from being an on-air radio personality full-time to going to being a paralegal, working in a law office. What was the reason for the change?
I needed a lifestyle change. The sleep schedule was very problematic for me. I never, even after that long of doing morning radio, I never got used to getting up at 3 o'clock in the morning. Ended up taking medication to help with sleep. Ended up getting addicted to that medication. That medication took over my life. So it was time for a drastic change. which is tough, because I, love radio, still do, but, priorities and getting healthy and getting good was certainly more important at the time.
Okay. Are you speaking of Ambien?
Ambien, absolutely, yeah.
Now, are you familiar with a Facebook page called Nevada Court Watchers?
I am the co-administrator of Nevada Court Watchers.
How long have you been affiliated with that page?
Since 2017-ish, mid-2017, a couple years, 2.5 years.
Is there anybody who administers that with you?
There is, Dave Shump is his name.
And did you guys create the page, or did you inherit from somebody else?
Dave came along later as far as an admin of the page. I took it over from somebody else. And that person, and I'm forgetting that person's name, but that person really had lost interest in the page. When I became involved, it was there wasn't a whole lot of activity. And there were members, but there wasn't a lot of posting going on and whatnot. So to answer your question, yeah, I kind of inherited that page.
Okay. What kind of, just to give the jurors some kind of context for what this is, what exactly is Nevada Court Watchers?
So it's a Facebook page, and it's a page where we discuss family court litigation, child custody cases, divorce cases, cases that are of high interest, meaning that they're being talked about on other pages or in the community. Talk about attorneys, talk about litigants, talk about primarily family court cases, although it's not locked into just family court, but that would certainly be the bulk of what's discussed on Nevada Court Watchers.
Does the group have any actual meetups, or is it simply an online presence?
We have, on actually just one occasion, so more of just an online presence. Some of us know each other. Most of us just know each other through our online profiles and messaging each other online, that kind of thing.
Is this a paid group, or is it free?
No, it's free.
And so that, you've got a lot going on. You work as a paralegal for an attorney, you have your own paralegal group, you still do on-air radio things, and you're the co-administrator of this Facebook page, right?
Correct.
Why get out there and do that as well?
At the time, in 2017, well, to back up, I have a lot of involvement myself in family court. I divorced in 2005. Have a daughter who is now 16, almost 17, who's just my life, who I love more than anything in the world. And so I'm familiar with the high conflict litigation, because my ex and I had been in that adversarial scenario at family court for a long time. So in 2017, things have been calm for a long time, but we were back in some litigation, and that's where I first discovered a couple other pages on Facebook that were talking about cases. One was called The War Declared on Clark County Family Court. One page was run by a group called Veterans in Politics. They also talked about family court cases. So I just had an interest in this stuff, primarily because I was going through it myself. And I've always had an interest in law. I almost went to law school before I took a full-time job in radio. If I had not done radio for 20 years, I would have gone to law school and been a lawyer. So I've always had an interest in this stuff, but in 2017, because of my own case and what was happening, that interest was amplified, I guess, for lack of a better term.
Okay. Mark, I'm going to ask you a couple of questions about all that information you just gave us.
Okay.
Touched on a lot of subjects. But first, how many people would you say participate in this Nevada Court Watchers?
It's tough to say, because the group, I think right now we're at 340 members in the group, but it's a public group, meaning anyone can view it. If you want to post into the group, you need to be a member, you need to join. But I know a lot of people check out the page on a regular basis that don't necessarily participate in it. But as far as active members, about 340.
Okay. And you mentioned having gone through a divorce in 2005?
Correct.
Okay, you say you have a daughter who's now 17, so you have one minor child?
Correct.
And when you divorced, there was custody issues, support issues, things like that?
Yes.
Okay. Was it a very hotly contested litigation, or did it all work out in the end?
Well, it's tough. I think it's worked out for my daughter, and that's the most important thing. That's all that counts. Yeah, it's worked out in the end, but these cases are tough, they're high conflict. And so there was definitely a custody battle. You know, my goal and my efforts have always been joint physical custody, 50-50 custody. That's what I've exercised with my ex-wife from the beginning. We've had some hiccups along the way. But to answer your question, yeah, I mean, it's high conflict. It's, you know, we were only married for 2 years. We've been in court for 14, so that kind of says it all. But you'll do whatever you need to do for your child. So.
Okay. You mentioned a couple of other groups that piqued your interest. You mentioned something called War Declared on Family Court.
Correct.
What exactly is that?
So that's a page on Facebook. I think they also have a website. I think they also have a YouTube channel. It is run by the group Veterans in Politics, and their founder, Steve Sanson is his name. And their goal is, well, their purported goal is to expose corruption in Clark County Family Court. So what happens when you, in trying to do that, they post.
I'm sorry, what was the objection?
There's no question.
Well, that's fine.
All right, you rephrase.
So is that, does it have a forum? Can people come and discuss things in this War Declared page?
Yes, it is set up very similar to Nevada Court Watchers.
Okay. And then you also mentioned Veterans in Politics International.
Correct.
What exactly is that?
Again, that's a group that says they're out to expose corruption. What happens when you look into that group is you find out that's where the corruption is.
Objection, there's no question.
That's overruled, who would answer your question?
Now, do you know a man by the name of Michael McDonald?
Yes,
And do you see him seated in the courtroom today?
I do.
And where exactly would he be?
He's at the defendant table, wearing a white shirt.
Does the record reflect identity?
The record will still reflect.
How did you come to meet this man?
Objection assumes facts, not evidence. Yes, if he knows him, not that he met him.
Okay,
Oh,
That's fine.
That's overruled, you can rephrase the question.
sure. When did you come to know him?
I came to know him in the middle of 2017, June or July of 2017. Mr. McDonald was discussing his divorce case on these two other pages, Veterans in Politics and the War Declared on Clark County Family Court. He was talking about his case, the specifics of his case.
You heard the testimony.
Overruled.
He was talking about
You can continue on.
the specifics of his case. He was candidly slandering the judge that was overseeing his
Objection.
case.
Can we approach?
You may approach.
Mark, if I could redirect us back to where we were going. You said that you became aware of who Michael McDonald was through his posts on War Declared and Veterans in Politics?
Yes.
Okay. Any other forums, venues, websites?
You know, War Declared had its own, I believe War Declared had its own website, not just a Facebook presence, not 100% on that. Veterans in Politics definitely does have its own website, in addition to a Facebook presence. YouTube as well. Many of Mr. McDonald's hearing videos ended up being posted to YouTube by Mr. McDonald.
And how does that work? Are you familiar with YouTube?
Yes.
So, how does one post a video to YouTube?
Well, my understanding is, you know, anybody can. You get an account, you open an account, set up your own page, upload the video of your choice or the videos, put a label on them, and they're out there for, you know, public consumption.
Do you need something called a channel to do that? Like a YouTube channel?
I believe you do.
Okay.
I believe you do. Veterans in Politics have,
Objection, there's no question.
That's no problem. And Mark, as you can see, considerable objections are coming from the defense. If you could just limit your answer to the question I'm asking, we'll
okay,
probably prevent that from happening.
go ahead.
Thank you. Why did you become interested in Mr. McDonald? He probably wasn't the only person posting, right?
That's correct.
Okay, so why Michael?
You know, his case was, well, Michael was, he was asking for input. He was asking strangers for input. What can I do in my case? You know, I think he was either I think he'd either lost custody of his children or he was about to. He said, look, I've got a judge who is corrupt. I have a judge who is biased against me.
Hearsay. Question is, why was he interested? Not what everything was told.
Your Honor, that's not hearsay, the defendant's statements.
The question was, why did he get interested?
Right, he's explaining why he got interested.
No.
That's overruled. That's overruled.
You know, became interested because those are pretty bold statements. You know, you say a judge is corrupt, a judge is biased. This judge and others are taking children away for no reason. Pretty salacious. It's attention grabbing, I think, by design.
Sure, no, I just want to make sure that we know, because you've been in the family court, correct?
Yes.
Since 2005.
Yes.
Is this the same judge that you were dealing with?
No.
So a completely different judge in the family court, Mr. McDonald was griping about on an online forum or two.
Right.
Okay. And even though that wasn't the judge, did you have multiple judges over the time you were in family court?
I have, yeah. I've had 2 or 3 just because of department shuffling and that kind of thing, but I've never had involvement with the judge that oversaw his case.
Okay. So even though it wasn't a judge that you personally knew and had dealings with, the comments he was making piqued your interest?
Yes.
Okay. Did you have any kind of contact communication with Mr. McDonald?
I did.
And how did that come about?
I actually reached out to him, and this would have been July 2017. I reached out to him through Facebook Messenger. That's an app that allows you to text directly, to message directly. And so I actually asked Mr. McDonald for more info on his case because I was interested. Specifically, I wanted to know if he had...
Objection narrative, he said he reached out for Facebook, which is the answer to the question.
Overruled. You can finish explaining his answer. You can finish. You can
Okay.
finish explaining.
I'll go ahead and hold.
Okay.
Sorry.
That's right.
May I report you with us?
You may.
Well, I'm showing you a document, it's a 2-page document that's stapled. It's marked States Exhibit 4, proposed. Could you take a look at that? Tell me if you're familiar with it.
Yes.
Okay? What is this document?
This is a copy of our exchanges, my communications with Mr. McDonald through Facebook Messenger.
Okay. Does this have to do with what you were just explaining about how you came to have contacts with Mr. McDonald?
Yes.
Okay. And is this an accurate copy of those communications?
Yes.
I move for admission of the state's proposed exhibit 4.
Any objection?
No, if you lay a proper foundation. Is that fairly accurate representation of conversation? Then I have no objection.
Mr. Raman, do you want to ask that question?
I thought that was my last question.
You just asked the
Do
question.
you want to ask that question again? You're free to.
Sure, I'd be happy to. That a fair and accurate depiction of a copy of the communications you had with Mr. McDonald.
For the second time it is.
No objection.
All right. It will be admitted. As stated in the, I'm sorry,
This is number 4, Judge.
number 4. Thank you.
May I have your clerk or reporter switch over to the document camera?
Yes.
Sorry for not prepping, sir.
That's okay. ladies and gentlemen, we have technology in here, which is sometimes redundant, sometimes not, so bear with us as it can be finicky. Today, at least it seems to be working, which is good news. Great enough. I think that's what we're doing.
No, okay, I'll just ask some other questions.
If you don't mind asking some questions, we'll get this set up for you.
Sure.
Thank you.
So Bart, we'll come back to that once we
Okay.
get this one. We'll get into the actual words of the exchange when we have the document on the screen, but
Okay.
you said you reached out to Michael?
I did.
Okay. Was he receptive to you asking questions about the things he'd been posting about?
Yes,
Okay, did you guys engage in a dialogue?
we did.
Okay. At some point, did you request more materials, or did he offer more materials to you?
I requested more materials from him.
What were you seeking?
I wondered if he had more of his hearing videos.
Okay, so when you say more hearing videos, was there already hearing videos that you had seen?
Yes.
And in what context had you seen these videos?
The same social media platforms we just discussed, Veterans in Politics, War Declared, YouTube. In fact, at that time, when I reached out to Mr. McDonald, he had just appeared on the Veterans in Politics talk show, which is a weekly internet show discussing the case in more detail. But the hearings were not being, what he was sharing was kind of cherry-picked, hand-picked, not in chronological order. So just said, hey, would you mind, do you have these videos, would you mind sharing them? And he did.
Do you have any knowledge on how you get videos of court proceedings?
I do.
And how is that?
You simply go down to the clerk's office at family court, you fill out a form, the video and transcript office gets a copy for you on either a thumb drive or they used to do CD-ROMs, and you don't even do that anymore. It's very simple, any case that's not sealed, any case that's public record, you can get those hearing videos within a couple days.
Okay, and those are in computer file format, or are they like DVDs?
They are in Windows Media Video format, WMVs.
Okay, so you
I
can.
know that just because I've got my own case.
Sure. So you know about this because you requested videos from your own hearings?
Yes.
Have you ever posted your own hearing videos?
No, absolutely not.
Okay. Is that a common occurrence that people will post on these forums?
Is it common? Yeah, but there is a theme.
Is that device you said at this point?
Try it again. If the light is blue, which gives me hope. No promises. Try hitting the blue button.
There we go.
There we go.
Perfect. Okay, publishing states Exhibit 4. I'm unfamiliar with Facebook, I don't have an account, so.
You don't have a Facebook account?
I do not.
Sometimes I wish I didn't have a
Objection, no questions.
I'm just giving context to my question.
That's it. That's the rules. We'll move on.
With regard to Facebook, there's a way to chat with people individually?
There is, through the Facebook Messenger app. You can do that on your desktop computer, you can do it on your phone. It's kind of a separate piece to Facebook. They run parallel together. It's just like a text message exchange or a direct message exchange through Instagram or Snapchat, similar.
Okay. And is that what you had with Mr. McDonald?
Yes.
Okay, I'm showing you the back page. Does this run chronologically from oldest to newest, back to front?
Back to front, yes.
Okay, so I'm showing you the back page of State's Exhibit 4. I'll zoom in. Okay. Is this the first communication you had with Michael McDonald?
Yes.
So that appears to take place in July of 2017?
July 16th, 2017.
Okay. you've already explained when we were killing time before this equipment, why you reached out to him. The next message on here, what is that?
You added Michael McDonald on Messenger. That is, I think that's similar when you send a friend request to somebody through Facebook, they have to accept it. There's some kind of protocol there. If you don't know the person, you have to reach out to them and they have to accept you as a quote-unquote friend.
Okay. And then similarly, the last one on this page, does that appear to be Michael adding you?
Yes.
Okay. So now that you guys are added on Messenger, you can communicate with each other?
Correct.
Okay. Going to the first page of State's Exhibit 4. And it goes from bottom to top, right?
Yes, it does.
All right, so I guess just use this pen as a reference. Sorry, this one. What exactly is the context of this message from Michael to you?
Just so we're clear, Mr. Raman, let's get a timestamp to it, so we're
Sure.
looking at it. It's timestamp 7:23 PM on July 16, 2017. What is the objection, Mr. Mueller?
I'll withdraw from the room.
Okay, you proceed.
So what's the context of him sending you a link?
Just that he was going to send me a link to some of his hearing videos. He sent me that link, or actually a series of links by email. So this message at 7:23 was followed up shortly thereafter by email, which you're not going to see here. 3 emails that are links to Google Drives that have hearing videos and so forth.
Okay, I'll show you that in a minute.
Okay.
Once we get through this document. Then there's communications from Michael. I'm pointing at something from 7:24 PM. Which you respond to. What is this dialogue here?
Mr. McDonald wants to know if I'm with the media, which I am, I was. He wants to invite me to an equal parenting rally in front of family court. There is so much corruption going along with that narrative of war declared and veterans in politics. I get then in the 7:28 PM exchange, I give him my email address, which is a Gmail account. Not presently in the media, used to host a morning radio show here in town. I'm always shocked at what happens in family court. Something needs to be done.
Okay. And then there's further dialogue on the top of this page, correct?
Yes.
Okay. And it looks like all of this, based upon the timestamps, take place on the very same day. This is all July 16th of 2017?
Yes.
Okay. So there's further dialogue, 7:28, 7:29, is that right?
Yes.
Now, the last message at the top, the 7:29 from you to Michael. So, are you acknowledging you received the links?
I don't think I had received them yet. I said if you're comfortable sharing the videos, I'd like to check them out. I don't think the email had come yet, but it was about to.
Okay. And I'll show you what you were referencing earlier. There's a couple of exhibits got consolidated, some have done consolidated.
Okay. If I can actually have the parties approach briefly.
Sure.
Before we move on to the next exhibit, there was a question to see the last message exchange at the top of page 1. There's been no objection to re-showing that, so I'm going to ask the state to do that. If you could just, again, reference what exhibit it is and what you're showing.
Sure, put it on the document camera, State's Exhibit 4, top of the document, first page. And this statement about my case has been crazy as well. nowhere near the extent of yours. I've been in and out of family court for 12 years now. Is that you authoring that statement?
Yes,
Okay, so you're writing that to Michael?
correct. And then it looks like he responded with a thumbs up.
Any questions?
Yes, thank you.
Mark, I'm showing you what's been marked as State Proposed Exhibit 2.
Okay.
Are you familiar with these documents?
Let's see. I am.
What are they?
These are emails from Mr. McDonald. Well, let me back up. Emails from me to Detective Colby Karchner. 7 of those emails. And then another email to the detective with a voluntary statement that I prepared. And exchanges with Detective Karchner.
This is the one. Sorry, may I first look at this? Right, I'm showing State's Proposed Exhibit 5. Do you recognize these documents?
I do.
And what do you recognize them to be?
The first stack here are emails between myself and Candace McDonald. It's Mr. McDonald's ex-wife. And that is followed by emails that I received from Mr. McDonald with links to his Google Drive. Three separate emails, 3 separate links.
All right, now our State's Proposed Exhibit 5 is simply the emails between yourself and Mr. McDonald?
Correct.
Okay. And are these a fair and accurate copy of what you printed from your Gmail account?
Yes.
Okay, they are. Move for admission to State's 5.
Any objection?
No objection.
It will be admitted, thank you.
Publish?
You may publish it.
Okay. What do we see on the screen here, Mark?
This is the first email from Mr. McDonald, July 17th, 8:25 p.m. And it is a link he shared with me to have access to the appeals folder in his Google Drive.
Okay, was that the only folder he shared with you?
No.
Okay, go on to page 2 of State's Exhibit 5. What is this?
This is the second link he shared to a document called the divorce chronology of events in his case.
Okay, is that a document or a folder?
That looks like it's just a separate document.
Okay. And then the last page of State's Exhibit 5. What is that?
And that's the third and final link, and that is to a folder called Court Videos.
Okay, so that one appears to have come to you at 7:45 p.m. on the 16th of July, 2017?
Correct. So that one would have come, looks like prior to the other two.
Okay. So again, back to front chronological.
You got it, yep, correct.
7:57 is the second page, 8:25 PM is the first page.
Yes.
And at the time that you received these, in July 17th of 2017 in the late evening, did you start to look at the materials then and there?
I did.
Okay. Did you look at everything that was in the drives at that time?
No.
Okay. Was there only a small amount of information or a large amount?
There was a large amount of information in these folders.
Okay. Folders are named, there's two folders and there's one document here. One says appeals, the other says court videos, and then one of them is a document. Were the materials in this appeals folder something related to appeals?
To the best of my recollection, yes. It was the hearing videos folder that had a whole lot more. I did not spend a whole lot of time in the appeals folder.
Okay. Court videos folder,
Yeah.
was it simply court videos?
It was not, no.
Okay, what kind of stuff was in there?
There was just about anything and everything. There was screenshots that Mr. McDonald had taken of his ex-wife's journal and diary. There were court videos, there were hearing videos, there were audio recordings, there were telephone recordings, some snapshots that made no sense. I didn't, in July of 2017, I genuinely just wanted to see his hearing videos, kind of fill in the blanks of what he hadn't shared. So I noticed all of this, didn't really pay much attention to it. The only thing I really looked at was the hearing videos.
Okay.
But within that folder, there was a whole lot more.
What was the point of giving you the links to these particular materials?
Well, I had asked for them, and I think that, at the time, Mr. McDonald wanted people to know what was going on in his case. He wanted opinions, he wanted feedback.
Okay. Did you give feedback?
I did.
Okay, what was your feedback?
Well, after watching the hearing videos that weren't shared online, and then many of those did follow later. Throughout the rest of 2017, Mr. McDonald was actively discussing his case, actively sharing materials, posting more videos. What would happen is, once you watch these hearings in chronological order, you quickly learn that what's actually happening in that case, in that courtroom, is not what Mr. McDonald is telling people is happening.
Okay, so you changed your perspective on the matter?
Drastically, yeah.
Did you indicate that to Michael?
I did.
Was he agreeable, or did you guys have some conversation about that?
Agreeable, no. Confrontation, no. Actually a lot of people, myself included, in Nevada court watchers, tried to help Mr. McDonald with his case. Because what was happening in that case was that Judge Marquis, again,
No question.
That's fine. We'll move on.
All right, will be sustained.
You said that you didn't go through absolutely everything in those folders night one, correct?
correct.
Okay. Did it take you a while?
A long while, yeah.
Okay. Many months?
Yes.
Sure. When we get into 2018, so you got this in the summer of 2017, you get to 2018, you said Michael McDonald had been utilizing YouTube to try to post videos?
Correct, yeah.
Okay. Did he post anything of interest in February of 2018?
Yeah, in February of 2018, there was a video that Mr. McDonald posted to YouTube. And it was produced with some, you could tell it was produced with some software that mixes photos with sound, with video clips, like an Animoto or a Filmora free download that will produce these videos for you. And a video appeared on YouTube on his channel where he was disparaging his ex-wife. There were recordings of phone calls.
Production, foundation.
Okay, do you know what about this was? We already established. I was asking you about February of 2018.
Yeah.
Okay, so hold on, that objection is sustained, you can ask your next question.
Okay. And with regard to this video, you were talking about recordings of telephone calls?
Yes,
Were you familiar with who the parties were in these phone calls?
I was.
And who were they?
It was Mr. McDonald and his ex-wife, Candace.
Were these complete phone calls?
No.
Starting with a hello and ending with a goodbye or see you later?
No, these were 3 or 4, maybe 5 different recordings, but they started kind of mid-call. It was not a start to finish type. Not a complete call.
Okay. So portions of telephone calls?
Yeah.
And you said there was like an animoto, like slideshow?
Exactly, yeah, a slideshow that, you know, you're hearing the audio in the background of these phone calls and these recordings, and then you're seeing pictures. Pictures of Mr. McDonald with his children. And then, so, you know, you would have this kind of narrative or this presentation of super dad, kind of super dad, and then evil ex-wife. Pictures from his ex-wife's journal, her private.
Mr. DiCiero, I'm having you describe the YouTube video. I haven't shown you the YouTube video. Is there a reason why that's not possible?
That is not possible, yeah, correct, it's not, because it was taken down shortly after it was posted.
Okay. And where did this video, was this posted by any particular individual?
It was posted directly by Mr. McDonald.
Objection, foundation, how does he know we're foundational to this?
Okay. When we talked
That's
about,
overruled, you can cross-examine him on that.
when we talked about YouTube previously, do you need to post things to one's channel? So, for example, if you had a channel on YouTube, would it be called Mark DiCiero's channel or whatever you decide to call your channel?
Correct, yeah,
And when you post things to YouTube, they would probably come up on that channel?
it would.
So where was this particular video posted?
Michael McDonald's YouTube channel.
Okay, and are you aware of any other people that had access to posting or taking down things from Michael McDonald's YouTube channel?
No.
Did you have conversations at all throughout your dialogue with Mr. McDonald about him posting or taking things down?
I don't know about a direct dialogue with him, but through the Nevada Court Watchers page, which at this point had become very interested in his case. Because again, he was asking for input and advice and so forth. Our page was talking about his case.
Narrative testimony, and there's no question.
The objection is overruled, he's finishing his answer. You may finish your answer.
So the page was talked, or the case was talked about a lot on Nevada Court Watchers. So when I saw the YouTube video, and I don't think I was the only one in the group, a couple of us posted the link to it, shared the link to the YouTube posting of Mr. McDonald, and said this is problematic for several reasons. You know, he's sharing a lot of intimate.
Hearsay.
I think he's getting communicated with Mr. McDonald about this particular video.
That's overruled. You may answer.
Sorry, I forgot where.
You were talking about how the video was problematic and you were communicating.
Yeah, so, you know, there were some very disturbing things that he was saying about his ex-wife.
Objection, narrative testimony. Witness just can't get up and say whatever he wants to, whatever pops in his head.
Mr. Mueller, we have no speaking objections. That is overruled, however, unfortunately, the interruptions, I think, have kind of taken us off course. If you could perhaps re-ask the question.
I think my original question was, had you had any dialogue with Mr. McDonald about him posting or removing things from YouTube? Could be either of those scenarios.
Directly with him, no. Through Nevada Court Watchers, yes.
Had he ever posted anything on Court Watchers, for example, come check out the video I just posted?
He was an active member of Nevada Court Watchers, as was Candace, his ex-wife. The extent of what he posted, I don't recall. He certainly participated in the page.
Did he ever post links to things that he had put on YouTube?
I think he did, yeah.
Now, when you saw the video that was on Michael McDonald's YouTube channel, the one with the photo montage and audio recordings, was any of that material familiar to you?
It was. That's when the light bulb goes off, and I'm trying to figure out where have I seen this material before? How do I know of it? And what really triggered that for me was the audio recordings.
On what basis?
Question was it familiar to you? The answer is yes, it was. Now he's
That's
going on.
overruled, Mr. Mueller. He can explain his answer.
Go
You
ahead.
can explain your
Can you
answer.
repeat the question, I'm sorry?
Sure. Were you familiar with what was in that YouTube video from some other source of information?
With the, yeah, okay, so, you know, the light bulb goes off. I've seen some of these screenshots before. I'm aware of some recordings, but what was through the Google Drive link that he shared with me in July of 2017. We're now talking February 2018, so it's been a few months. And I remember those things existing on his Google Drive, not things that I really looked at or checked out, because I just wanted to see the hearing videos. So at that point, I kept those emails. I'm thinking, you know, I wonder if these links still work, and sure enough, they did. And so all the material he put in that Animoto video, all the screenshots, all the pictures, the audio recordings, all those files, all that material was in his Google Drive that he had shared with me.
Okay. So you verified that?
Yes.
And did you retain copies of the phone calls? Or download them or whatever?
Eventually, yeah.
Eventually.
And I also let, you know, yeah, I did.
Now, with regard to you saying there's something seriously wrong with this video, did you point that out to Mr. McDonald?
I did. On
How
Nevada
did you
Court-
do that?
On Nevada Court Watchers, I posted, some other members posted, that, A, it's just dirty. You know, it's just, it's not cool by any stretch.
Coach,
You may.
Without giving you your opinion on the morality of the video, did you communicate that you felt there was something wrong with this video to Mr. McDonald?
Yeah, so aside from morality, there was some dialogue about the legality of recording phone conversations in a two-party consent state.
So you communicated that to him?
Yeah, well, again, not to him directly, on Nevada Court Watchers.
Okay, so you posted it out in the open where Michael could see that,
Yes,
in the forum that you know him to frequent?
correct.
Now, I'm not exactly sure how the forms work, but is there a thread on a subject? So would there be a subforum for the Michael McDonald case, or how does that work?
No subforums, kind of a free-for-all. Any post that people want to comment on, they can do that. Threads form underneath that post. But it's certainly not a dedicated part of the page to his specific case.
At any time leading up to this, did you know a person by the name of Candace McDonald?
Yes.
Did you, I mean, when I say no, I guess I should be more specific. Did you have any communication with her?
When this was happening in 2018, 2017?
Yeah.
Yes.
Before the video was posted by Mr. McDonald?
Yes.
Okay, and how did that come about?
Candace had become a member of Nevada Court Watchers. I don't know this, I think that she just, you know, saw that the case was being talked about.
objection, here stands speculation.
That's not awkward for the truth, it's how he came to know Candace.
That's a little.
She joined the page, as did Mr. McDonald. She communicated about the case. She participated, not nearly as often as Mr. McDonald, but I think she was, yeah. So that's how I became aware of Candace, and that's how I became to know Candace. I did not know her prior to any of that in 2017.
Did you know her personally?
No.
As a, you know, associate, friend, anything like that?
No.
No. Okay. Did you have any communication with Miss Candace when that video was posted?
I did.
And how did that come about?
Well, you know, initially it was on Nevada Court Watchers, like we just talked about, and then I also messaged her privately. That would either have been through Messenger or by text message or something, saying, hey, these phone calls are in the Google Drive link that was shared with me, that now appeared in the video that's on YouTube, and you know, I reached out to her out of concern.
Okay. You already testified about Michael having reviewed that video shortly thereafter, is that
Correct.
Was that after criticism of the video or beforehand?
It was immediately after criticism of the video, specifically criticism of the legality of recording phone calls in Nevada.
Was something similar to that video ever reposted?
Yes.
And can you explain that?
The exact same video with the same recordings, same screenshots was posted again 5 weeks later on YouTube by Mr. McDonald, on Mr. McDonald's YouTube channel, with one slight difference in the video.
What was the difference?
The difference was inserted in the middle of these conversations, and to give context if I can, you know, in these recordings, I don't know if they've been played for the court or if they're going to be played, her voice is very loud. Michael's voice is very low, it's very muffled in the recording. So in the recording, all of a sudden, is Michael dubbing in.
Objection.
Well, if you could describe it without using the word dubbing.
That's the state.
Okay. In the middle of the recordings, or in the middle of the video, within these recordings, is Michael all of a sudden telling Candace that she's being recorded.
Okay. And did that seem odd to you?
It did.
Why?
Because I have a radio background, I know a lot about editing and dubbing. It was a horrible attempt at dubbing. His voice was very low. When he's telling Candace that she's being recorded, it's all of a sudden very loud. It's almost overlapping his own words. So it would be, you know, it was, and not to be rude, it was humorously.
Mr. DiCiero,
Is that
what is the legal basis for
not
objection?
noticed as an expert witness, giving his opinion on technical matters?
That's overruled. Mr. DiCiero, you can testify as to what you witnessed, what you saw, what you heard.
Now, going back to the earlier point, so the video now has been posted twice, second time with some addition, correct?
Correct.
The recorded phone calls, did they ever feature any kind of advisement of somebody being, hey, this is being recorded? Something from Mr. McDonald conveying to Candace that it was in fact being recorded?
In the second video in March of 2018, yes.
But what about on the recorded phone calls that were in Google Drive?
Not at all.
None of them?
No.
And you checked those phone calls before the second video was posted?
I did.
And they weren't in there then?
The phrase "you're being recorded"? No, absolutely not.
At some point, you said 5 weeks later. We were already talking about February is when the original YouTube posting happened, February of 2018?
Yes.
So you're talking about sometime mid-March is when the second version of the video was posted?
Yeah, early to mid-March.
Okay. Does that video stay up for long?
It did, yeah.
Okay. Does it eventually get taken down?
Eventually. And when, I'm not sure. I can't tell you.
Did you have communication with Miss Candace McDonald when these events were happening?
Yes.
Did you provide her copies of the phone calls that you had seen in the Google Drive of Mr. McDonald?
Yes.
Yeah, first.
You may.
And you want to approach on the question?
Go ahead and approach first, and let's see where we are.
Mr. DiCiero, showing your state proposal Exhibit 1, do you recognize this item?
I do.
What do you recognize it to be?
This is a CD of the audio recordings that we listened to in your office and that of Ms. Mishler.
Okay, and what are the recordings of?
These are the recordings that were in Mr. McDonald's Google Drive, the phone calls, and the recordings that appeared in that YouTube video.
Okay, and is this a fair and accurate copy of those recordings?
Yes.
Is there any, I guess, handwriting that you put on this disc to verify that you in fact verified that?
My name is here, and the date is January 3rd, 2020. Looks like Candace's signature is also on here with the same date.
Okay, did you do that after listening to the recordings?
Yes, I did.
Move for admission of state proposal to one.
Any objection?
No objection.
All right, it will be so admitted. Because I didn't have counsel approach the bench. All right, so that exhibit will be admitted. We do have a question from the jury. Mr. DiCiero, in the second video, did Candace acknowledge being recorded?
She did not. No.
Thank you. Ladies and gentlemen, we're actually going to take our lunch break now. It's kind of a natural breaking point before we continue with the presentation of evidence. It is about 12:25. We're going to break for an hour and 15 minutes. So we'll be back here at 1:45. During this lunch recess, you're admonished not to talk or converse amongst yourselves or with anyone else on any subject connected with this trial, or read, watch, or listen to any report of or commentary on the trial or any person connected with this trial, but any meeting information, including without limitation, newspapers, television, radio, or internet, or form or express any opinion on any subject connected with this trial until the case is finally submitted to you. So we'll be in recess until 1:45, and we'll see you then. Enjoy your lunch break.
All rise for the jury.
All right, let the record reflect that the jury has left the courtroom. Mr. DiCiero, you're still under oath. Like the parties, I've instructed you shouldn't have any contact with the jury or anyone else from the court during the pendency of this trial. Yes, Mr. Mueller.
Given the special circumstances of this case, may this witness be admonished not to talk to anybody about his testimony until he returns to the stand?
Yes, you are currently still under oath and still what we'll call a live witness, so we can discuss your testimony with anybody during this lunch break as well. Okay, so if you can come back, everyone be back about 1:40, where we can settle in and we'll just resume the questioning at that time. Okay, thank you very much.
Thank you.
Is everyone then?
Court is in recess.